Testing. Solo. Yeah, there's not a good way to do this. All right. I tried to wait and see. Oh, I was like, I just want to see how it sounded.
Testing, testing, 1, 2, 3, 4.
It's so much like. Maybe, yeah. Ton better. That's toast. Can you just hit the mic, or actually let me do that, and can you mess with the bench camera? I don't know how to blow it up. All right, here we go. Testing, Judge 1. Testing, Judge 2. Testing, Justice 3. Testing, Justice 4. Testing, Testing, Judge 6. 5. Testing, oh. Testing, Judge 7. Okay, so that's. This one right here is. Let's see if I can turn this up. Testing, testing.
There's a volume back that might be it. I think it should be all the way up. So
It's all the way up?
yeah.
That was a little quieter. This one is not.
Testing? No? Yeah. Testing? That one sounds better.
Testing. All right.
So there are two appellants. One is PDS. That's the first argument. That's right. The second one is the state of Maine. They're both appellants. Yes. The appellees are the plaintiffs, the defendants, slash inmates, slash people who are entitled to court-appointed counsel. So, yeah.
Testing podium mic. Oh, all right. Testing podium mic. That's better.
They're representing the appellees.
If you have the past paper too, like,
So how did you put up Justice Lopez's?
I put up Justice Hortons and I propped Justice Lopez right in front of me.
You're so smart.
Wow, you know.
Morning, Jay. Good morning. How are you?
She just gets
If that's the bar, I'll just have to warn her, hey, the back of yours says Horton, don't touch it.
Yeah, don't touch it.
Yeah, yeah.
I never thought PCR.
All right. I'm gonna find a pen.
So this is on, but no, oh boy.
Yeah. No, they should be on. We switched that one out, so it's actually working. Hang on. I'm gonna warn them about that one.
able to see that. All right, I'm going to unmute the screen. Test it one more time. So it's although that is no our battlefield.
No, no, I fixed it. Sorry.
So I'm just gonna, oh. So testing justice 7, or 6, I guess. Testing justice 5. Testing justice 4. Testing justice 3. Testing justice 2. Testing justice 1. Hello. Kind of low. So testing justice 7, although I'm kind of far away.
Yeah, sit down.
Testing justice. Testing, 1, 2, 3, 4. No, what? Gotta turn it up. Well, you can house it on yeah, on that. You can turn everything up there. So testing, 1, 2, 3, 4. Should go into the yellow very occasionally, basically. Testing, 1, 2, 3, 4. So testing 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Well, but this is like all the way up. And this is before we turned it all the way up. And where's it showing up on the monitor on that?
It's right
Into the yellow a little bit? All right. I think that works. Is it right out there?
Yes.
Hi. Yeah, or these chairs, but yeah, probably we can
It was expected that some of us should be here.
get some.
We have
Sure.
ways that are ready.
Sure. So testing 1, 2, 3, 4. Wow, that's loud.
That's a little loud. You can turn that one down your back. Turn it to your left. Yeah, sorry, a little weird.
Hard to do backwards.
Try that again.
Testing 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Just barely touch me. Much better. Yes, it's going to. I think you're right on the speakers right there.
isn't too much I can say that hasn't been said already, but this really is an awesome opportunity. I haven't seen anything like this specifically in any other state. It's a real privilege to have the Maine Supreme Court here in your school. It's similar to watching a court on TV, except it's live, and this has real influence and impact on the people whose cases are being heard and on our judicial system as a whole. It's really something that I'm excited to be a part of. My name is Tristan Peters. I'm a local attorney. I work in Skowhegan. But let's talk a little bit about the actual process. So there's a light up there, and the light will indicate the amount of time that the speakers have. Each party will have 15 minutes. The appellee goes second, the appellant goes first. The appellant will have 3 minutes where questions won't be asked of them. After that 3 minutes, the Supreme Court justices can ask questions for the next 12 minutes. It's up to the appellant if they would like to have 3 minutes saved to come back on a rebuttal. But if you see a white light illuminated, that means the justices won't be asking questions for 3 minutes. When it's green, the justices may intervene and ask questions. And after that, there won't be any questions once the time is up. And yellow indicates 1 minute remaining. So I'm going to talk about the first case briefly. Are you all able to hear me okay? So the parties for the first case are, on behalf of the defense, Dan Lawson, and on behalf of the state, Jake DeMoss. So the first case has to do with a probation revocation. Initially, the person was sentenced of a crime that is now in question as to whether or not it is still a Maine statute, whether it's a valid statute. That person is facing real consequences on the probation side of things. And the question is whether or not that case or the probation side of things should have a sentence where the underlying charge may be invalid. The expected arguments by the appellant are that Mr. Lemieux's probated sentence is unconstitutional on its face. The trial court erred by determining that Mr. Lemieux's conviction was not subject to collateral attack. Maine's post-conviction review law does not preclude a trial court from considering the constitutionality of a prior sentence, and that other courts have recognized that it is inappropriate to impose a suspended sentence that was unlawful from the start. The appellee, the state, will be asserting that 15 MRS section 2122 clearly states that the only means of collaterally attacking a conviction is through the post-conviction review process, that this isn't the proper forum for addressing that issue. And they've indicated that there have been new procedural safeguards for prosecutions of true threats, and this whole thing is not retroactive. Further, the defendant was convicted after the decision in countermand, so the issue is not relevant to this appeal. And lastly, they're asserting that even if the court were to allow review of the statute at a probation revocation proceeding, Maine's terrorizing statute is nonetheless facially constitutional.
And just a quick reminder that after this argument and after the court leaves the stage, if the attorneys have agreed to stay behind and answer a couple of questions.
All rise. All persons having anything to do before the Honorable Justices of the Supreme Judicial Court, sitting in the law court at Valley High School, within the state of Maine, they come forth and declare it, and they shall be heard.
Good morning. You can be seated. Good morning, everybody. I'm Chief Justice Stanfill of the Maine Supreme Judicial Court. Ordinarily, as soon as I say you can be seated, I call the first case. But because we're here, I'm just going to take a few minutes to introduce us and to introduce the court. As I say, I'm the Chief Justice and have been for, I guess I'm in my 5th year now as Chief. With me, I have, for this first case, only 4 other associate justices. One of the justices has recused herself on this first case, and we're actually short one justice on our court, waiting for the governor to nominate a replacement for a justice who just recently retired. I am actually really happy to be here. I love going to the high schools. We love seeing the students. We hope that you enjoy seeing, at least somewhat, what is the third branch of government, which a lot of times people forget that there is a third branch of government. They think about the legislature and they think about the executive. In the state level, that's the governor. The federal level, that's the president. And they forget about us. But we are the third branch of government in this state. And we are the highest court in our court system, so that when people appeal cases, we are the highest court in our state court system that they can appeal to. And so we hear arguments as opposed to trials. We don't get witnesses, nothing like that. We just hear arguments. I want to acknowledge some of our special guests here today. We have Representative Caruso, who is here, who represents this area. We also have Senator Black is also here from this area. I understand that Leo Hill, the chair of the school board, is here somewhere, and other members of the school board, I think, couldn't make it. You've all, I think, met Tristan Peters, who has agreed to work as what we call the lawyer of the day here to help explain things and answer questions, because we can't talk to you about the cases. That's part of how it works, right? We kind of have a shield up. We can't talk to you about the cases. Is the principal here, Mr. Tyler? There you are. And Mr. Hartwell? There we go. I hear that you've taken interest and interact sometimes fairly frequently, and so and that you may be one of the folks who really wanted us to come here. So thank you for inviting us. Thank you as well to the custodial staff and the folks who set up the AV for us, the auditorium setup, and welcome to the students. This may not be as exciting. I understand you had a visit last weekend from Cody Lawyerson, who is now with the Minnesota Twins. So that may be much more exciting than we are, but you know, maybe we're celebrities in our own right. I don't know. So I'm going to let the other justices here introduce themselves, and then we'll move into the first case. By the way, we operate very traditional ways, and we operate by what we call seniority. We have a very specific way that we sit. We always sit the same way, and we will introduce ourselves by way of seniority too. So I'll call on the Senior Associate Justice.
Good morning. My name is Andrew Mead. I'm the Senior Associate Justice. I've been a judge for the last 35 years. I served on the District Court, the Superior Court for the last 18 years on the Maine Supreme Judicial Court. It's great to be here today. My chambers are based in Bangor, but it's just a wonderful day, with wonderful weather, and one of the most beautiful corners of the state. Thank you for having us.
I'm Catherine Connors. I'm the only one of these justices who was never a trial justice. I was a lawyer for a long time. I've been on the bench since February 2020. I live in York County, and my chamber is in Portland.
Good morning, I'm Rick Lawrence, and thank you for having us here. This is a beautiful part of the state, and I hope to come back up here in the not too distant future with my family. I have been on the bench for 25 years. Most of that time was spent on the district court until I was elevated to the Supreme Court in May of 2022. I live in Portland, and my chambers are located in Portland.
Good morning. My name is Wayne Douglas. You may be wondering why we're bouncing back and forth like this. It's because we're seated in, as the Chief Justice said, in order of seniority. So it's the Chief and then first, second, third. And so obviously I'm the least senior in the panel here today. I want to thank you for having us. It's a pleasure to be here. I haven't been up in these parts for many years. It's really quite beautiful. It's a stunning day. I sit in Portland, and I have been on the bench. I was on the trial courts for about 20 years, and I've been on this court, the Maine Supreme Court, for about 2.5 years. Thank you for having us.
And in case you didn't figure this out, we usually say by seniority we mean term on this court, not how old we are. And I didn't mention, but I also have been a trial judge before I was on this court, so I'm coming up on my 20-year anniversary, and my chambers are in Augusta. And in contrast to some of my colleagues, I've actually spent a lot of time in this neck of the woods and ate many a meal back at Thompson's when it was open, for those of you who've been around long enough. Best strawberry shortcake ever. But anyway, that is who we are, and we're going to now proceed into the first case. So, the matter before the court is State of Maine versus Dennis Lemieux. It is docket number KEN 24341. Are we being streamed? Okay, just by video or both? Okay, so we are being streamed on the web by audio and video. And I see counsel are present. I would ask the counsel introduce themselves by saying their names for the record, together with the party they represent, starting with the appellant.
My name is Daniel Lawson. I represent the defendant, Dennis Lemieux. My name is Jake Demosthenes. I represent the state.
Thank you. And Attorney Lawson, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, and may it please the court. Again, my name is Daniel Lawson. I represent the defendant, Dennis Lemieux, in this matter. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievances. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Those words, perhaps more than any other, define our nation's character. A nation in which certain rights and privileges, such as the right to speak, belong to the individual. It is not the government's role to censor speech based on what is valuable or what it deems invaluable. Those are matters for the citizens themselves. Indeed, the First Amendment's mantle covers speech that is vituperative, abusive, and inexact. Individuals, whether in their private homes or public forums, are generally free to express themselves as they please. Now, those words, of course, come from our nation's highest law, the U.S. Constitution, a law to which all others must yield. But unless those words are given effect, respected by presidents, honored by legislatures, and implemented by judges, they are mere aspirations. In Mr. Lemieux's case, those words were not given effect. He was convicted and imprisoned, then placed on probation for speech under a statute that is unconstitutional on its face. Therefore, that law should be treated as no law whatsoever. It was void, and so was his conviction. Mr. Lemieux brought this to the court's attention when the state attempted to revoke his probation. Instead of giving effect to the Constitution, the trial court determined that inferior laws prevented it from doing so, and it improperly imposed a sentence that was clearly illegitimate. This was error, and the court should reverse that decision. I'd like to start by stating something that I think the parties can agree to.
Counsel, I note that the green light is on, so if you don't mind, I'm going to jump in at the moment. In this case, your client was convicted of terrorizing, correct?
That's correct.
He was convicted of terrorizing because he pled guilty to the charge.
That's right.
He pled guilty to the charge some months after the U.S. Supreme Court, in the Counterman decision, raised issues about the constitutionality of our terrorizing statute, right?
That's correct.
But he chose to plead guilty anyway.
That's correct.
What do we do with that?
Well, I'll point out a few things. One, Counterman was decided before he pled guilty.
I think Counterman was in June and he pled guilty in October of the same year.
I think that's correct. I don't know, I wasn't counsel for him, but I suspect that the full implications of Counterman may not have been understood at that point. Counterman, of course...
But we assume that you know what the law is.
That's true, but even now, the state argues that the statute is constitutional, so counsel and the court itself might not have recognized the issue.
So this isn't really a question of retroactivity, is it?
I'm sorry,
This isn't
I
a
can't
question.
quite hear.
This isn't a question of retroactivity, is it?
I think there's no doubt that it is.
How is this
it is retroactive.
How so? He pled, as the Chief just noted, he pled after the change of the law.
He pled after the change in the law, but he cannot, if it's a question of waiver, which is, I think, the question that we're getting at, he cannot waive his rights to the extent that he pleads to...
So what's his remedy?
I'm sorry?
So what is his remedy then? That's the question, right?
His remedy is that his conviction is nullified. It's nullified by operation of law. He could not plead to an...
Tell me how you say that, but you say it's like it's void, like it's no conviction at all. What is your authority for that?
The Supreme Court of the United States has said as much. An unconstitutional law is as no law, and conduct condemned...
Has there been a determination that this law is unconstitutional? I haven't seen a law court argue.
Well, I'm asking for one, and the court should recognize it.
But your problem is that this is a probation hearing, so you're collaterally attacking that conviction. And isn't at least the majority view elsewhere that you cannot collaterally attack the judgment in a probation revocation hearing?
Yeah, I think the court is referring to what federal courts call the Francis-Shine rule. And the precedent...
And states, there are other states that also say you cannot collaterally attack. So you're asking us to adopt a minority view, aren't you?
I would disagree. Actually, I would say that the trial court here extended the Francis-Shine rule farther than it has ever been extended before. Those decisions all involve kind of as-applied challenges or challenges that don't involve jurisdictional defects.
Can we just back this out a little bit to put it in context? I'm going to ask you to answer Justice Douglas's question from earlier today. The sequence here is Supreme Court pronounces some law in terrorizing cases. Your client pleads guilty to terrorizing. Something happened, apparently he had some contact, said something, and then the state began an entirely new proceeding called a probation revocation hearing, where the issue was if he did something at that point, should part of the sentence be imposed? Justice Douglas asked you, what's retroactive about it? Usually with retroactivity, somebody pleads guilty, something happens, and then afterwards, the Supreme Court will hand down a case. The issue is whether or not that new law applies to something that happened in the past. This is the exact opposite of that. This is the Supreme Court hands it down, he pleads guilty. It's the opposite of retroactivity. And I don't think you answered his question.
And I don't think that the order necessarily matters.
Really? Then why do we call it retroactive? Retroactive is backward looking.
The Counterman was retroactive in the sense that it effectively nullified the terrorizing statute
Well,
from the beginning.
back up for a minute. Counterman decided that there are certain limits on what could be criminalized on a terrorizing statute. Counterman did not decide that the Maine terrorizing statute was unconstitutional. It was not addressing the Maine statute. No one has, at least to date, the highest court of this state, nor the U.S. Supreme Court, none of us have said that it is unconstitutional. So your client pled guilty to a statute that could have been attacked. He chose not to. Why isn't that waiver? One can waive raising a constitutional issue.
It can on an as-applied constitutional challenge. With a facial challenge, it cannot be waived because that law is void. He couldn't plead to an unconstitutional terrorizing statute any more than I could plead to eating too many Oreos. Because that's not a law.
Sometimes two things can't be true at the same time. You say the law was void, but you also acknowledge that there's been no decision by either the Supreme Court or our court saying that that DV terrorizing law is void.
No, but the law does not become void when a court recognizes it. If it's void on its face, it's just an acknowledgement that it was void all along.
So if we accept that, just in the short time you have left here, if we say yes, counterman can be applied retroactively, meaning to cases that occurred beforehand, and if we say probation revocation is not an appropriate forum to attack the underlying conviction, is there a process in the state of Maine for attacking what happened at the trial level after the fact?
The PCR law would remain available.
So the post-conviction review would provide your client
And in
with
fact, you have a petition for post-conviction review. What's the status of that?
That has been stayed while this appeal is pending.
That seems a little backwards, doesn't it?
It does, and I should say, just because one door is open doesn't mean the other door is closed.
Well, even if we give you the opportunity that you're suggesting you should have had it in connection with the probation violation proceeding, he didn't raise it at that proceeding. That proceeding took place, did it not? There was a determination made that there had been a violation. Sentencing was put off for a while, and everybody had an opportunity to brief as to what they thought the sentence should be, which is the point at which he then introduced his argument that the DV statute, I believe the DV terrorizing statute, was unconstitutional. Is that not correct?
I believe that it was raised earlier, Your Honor, even before the sentencing stage.
But we're here today talking about whether you can collaterally attack the underlying conviction in a probation revocation proceeding.
I would say the question might be a little bit different, actually. You don't necessarily need to collaterally attack the conviction. You could take a narrower view and say, well, you can't impose a punishment. Okay? The court doesn't have the jurisdiction.
Well, if the conviction is valid, you can certainly punish. And the reason we talk about collateral attack is we don't let people generally, as a general rule, undertake this and say, my probation's not going to be valid. I'm going to violate it. I'm going to commit new crimes. I'm going to have this and that, and you can't touch me because it wasn't any good to start with. I mean, we don't allow it to proceed that way ordinarily, do we?
Right, and this is an exceptional case. Okay, this it's not an as-applied challenge, it's a facial challenge. It goes to the court's power, its jurisdiction, to impose a punishment under an unconstitutional law, which long precedent from the United Supreme Court has said that it cannot do.
And Counterman itself did not strike down the Colorado statute as facially unconstitutional.
No, that one might have been open to a saving interpretation. As I say in my brief, our statute is not open to such an interpretation. Thank you. I see my time is up.
Thank you, counsel. You'll have some, I think you reserved 3 minutes for rebuttal, so thank you. Counsel for the state, is this a jurisdictional issue?
I don't believe it is, Your Honor. I think that this case is a pretty straightforward case.
Assume, and I know you don't agree that this is the case, but assume that the statute is in fact unconstitutional on its face, that it can't be saved. Does that mean that there's no jurisdiction, or is it really voidable?
I don't think it's a jurisdictional issue. I think it's a question of whether or not the First Amendment prohibits the state from criminalizing either this type of conduct or if the statute is constitutionally overbroad, which from the state's perspective it is not. I don't think that's a jurisdictional issue. I think that is simply a plain First Amendment issue, which we've seen over the course
So
of
the
our history.
PCR was stayed pending this appeal? I mean, your argument has been that that was the appropriate vehicle, right?
Yes, Your Honor, I'm not exactly.
And so did you agree to have it stayed? It just seems backwards.
I don't recall, I don't want to speak out of turn. I don't even know if either of the parties requested it or if that's just how it went within the court system.
Okay, thank you.
But I think that the question that the defendant raises is whether they have a choice between using the PCR process or instead simply violating their probation and challenging the underlying conviction that way. Although Attorney Lawson argues that because one door is open, it doesn't mean the other one is closed, that might be true if this court wouldn't have said explicitly that those other doors are closed. This court has said it, the PCR statute has said it, that is the exclusive means of challenging an underlying conviction is post-conviction review.
And I think I heard Attorney Lawson say that, counterman came down in June, and this plea was in October, and, maybe the word hadn't gotten out to everybody was completely aware of it. And he didn't say this out loud, but perhaps is arguing for a flexible approach that counsel simply may not have been aware of it at the time, and we should let that go by.
So I think there's 2 points there. First off, I don't think there's an authority to say that because this is a certain type of case, lawyers don't necessarily have to be aware of it when their clients are pleading guilty. I don't think there's any authority for that. Secondly, if the issue is ineffective assistance of counsel, then we certainly do need a PCR hearing. We do need evidence to be entered into the record so that that court and then potentially this court can determine whether or not, and I apologize if I get the Strickland test wrong, but whether or not that lawyer's performance, didn't meet what a reasonable and prudent attorney would do.
So if the post-conviction review proceeding is terminated for some reason, technical basis, timing, something else, then in this case, Mr. Lemieux is without a remedy for something that might be a colorable claim. Is that something that we should look upon favorably?
I think that this court has been very clear that the purpose for this exclusivity portion of PCR, of the post-conviction review statute, is about the finality of judgment, is about the public's confidence in the criminal justice system, that when, whether it's a jury or whether there's a plea, once that appeal has been completed, that those judgments are final. I think that is an important consideration, and I think that's what this court has highlighted in all of its cases on this issue. And I think Johnson is so clear on this point that it talks about on paragraph 19 that all these provisions, it described the fundamental requirements for jurisdiction in the PCR, the venue for the PCR, the exhaustion of remedies, the filing deadlines, the available relief, discretionary appellate review.
Let me ask you this, counsel. Assuming we agree with you that a PCR is not only the appropriate but the exclusive way, post-conviction review is the exclusive way of raising this challenge. Isn't there an issue of judicial economy? I mean, should we be addressing the constitutionality of the statute in this proceeding anyway? Or does it make sense for us to say, well, you really have to do this in a post-conviction review, so go back to the trial court, have a hearing on the post-conviction review, and, we'll see you in another year or two when you come back up to see us?
So I think there's 2 points there. First off, certainly the state, on the principle, or perhaps technically or functionally, is perfectly happy to have this court determine whether or not the statute survives. We think it does. But there is a reason, as I've already said, for the PCR being exclusive. And so in a future case which comes down, why wouldn't a defendant at their PV hearing, at the sentencing, then say, there's a constitutional problem, because maybe, just maybe, this court will take it a whole lot quicker. And as I was saying, all of those provisions that I had just described before your question, those are all for naught. That's what this court has called it. If simply we can pull this in and get rid of the PCR and just go through the PV. All of those rules outlining how the post-conviction review statute is supposed to be handled, how defendants are supposed to challenge their underlying convictions or their convictions at all of those provisions would mean nothing.
Can we talk about the statute itself?
Sure.
We'll shift over. The charge here that he pleaded guilty to is terrorizing. Terrorizing is a crime that's committed with words.
Yes.
Correct? And the crime is committed if the person communicates to another person a threat or commit a crime commit or cause a crime to be committed of violence dangerous to human life. So if someone says something, you know, oh, you just dropped my book in a puddle, I'm going to kill you. No one would believe that that person really was intending to kill them. So our statute simply says if the person who received the threat believed it was going to happen, boom, the crime has been committed.
Well, I believe it says it has to be reasonable. It has to be a reasonable belief that that person,
But didn't Counterman reject that basis?
So the counterman, so I certainly would acknowledge that what Counterman did is said that in order for the prosecution to succeed, they must prove that the defendant was at least reckless as to the threatening nature of the speech.
And where is that required? The statute we're talking about has been amended.
Certainly.
The current statute does use, does require mens rea, but where is it in the other statute, the old statute?
And I think this is a central point, that it doesn't, that because the statute may criminalize some protected speech does not make it invalid. That's categorically true. That laws are constitutional which touch on protected speech. Now, how do we deal with this? The state has to prove at least recklessness.
No, it doesn't have to prove any mens rea under the old statute.
But
The statute is very clear, quite the opposite. It says if the defendant in fact makes a threat that has this consequence, and it doesn't require that there be any intent or other what we call mens rea, that the statement in fact be threatening.
And absolutely, I'm not disagreeing with you there.
And how can we read it in if the statute says actually to the contrary? It's not just silent, it says to the contrary.
So I would perhaps quibble with the contrary. I think it doesn't say that a mens rea is required, but nonetheless, we have jury instructions, we have rules for court which are not in the statute. And so, for instance, we have, and we all know that it's protected speech to go out on the State House steps and to burn the Maine state flag, right? The Supreme Court had the very, Texas v. Walker, I believe was the name of the case, right? There are statutes which prohibit lighting anything on fire without a permit, right?
You just
So
raised
that
a point that I hadn't thought of before. As you know, at the end of any jury trial, before the jury deliberates, the judge provides instructions to the jury, and they're well known. If it's intentionally, knowing, or recklessly, the judge will say you have to find that the person acted intentionally or knowingly or recklessly in doing this. If the judge gave those standard instructions in a terrorizing case under the old statute, is that okay?
I certainly do think it's okay, and I think it's okay because not every jury instruction comes from defining and interpreting the statute. It can come from other important laws, like the U.S. Constitution, like the state constitution.
But before Counterman had a trial judge on Maine's terrorizing statute said, I'm going to tell the jury they have to find that he acted intentionally, knowingly, or at least recklessly. You, as the state prosecutor, would have objected, saying that that's not required under the statute, wouldn't you?
Well, perhaps I would have, but if there was some constitutional provision.
And what were the jury instructions here?
This was a plea.
Oh, it was a plea.
So because he pled, again, and this is also what the law court describes a Vermont Supreme Court decision, and they quote from that, talking about quick appeals should be encouraged, that you shouldn't be able to not raise these issues, and then all of a sudden you violate your probation conditions by, in this case, having threatening contact with the alleged victim, and then you get essentially an extremely expedited post-conviction review. Post-conviction review, as we are all aware, sometimes can take a long time. Why would it be that we would allow somebody to get an expedited track to get any conviction reevaluated simply because they choose to violate their probation conditions?
I just want to be clear on one thing. You're not suggesting that that's what this particular defendant did. That, in other words, I want to find out if my conviction's going to stand up, so I'm going to go violate my probation.
No.
But you are talking about this being something that we should be concerned about going forward.
Yes, exactly.
Everybody says, I can skip this step.
Exactly, Your Honor. In no way am I saying that this defendant himself was thinking through Counterman at the time that he made these messages and these posts. But nonetheless, that's the policy implication at issue here, and I think it's an important one and again, they talk about this in Warren, which Justice Lopez cites in her decision in the lower court, that Warren says that this would be unfair to those people, those probationers who comply with their probation conditions. They go through the entire process, and they're wading through all of the deadlines and everything through the post-conviction review statute. But if they wouldn't have complied, it would have been a faster way for them to get review. I don't think that's appropriate. Nonetheless, though, as I've argued to you all today and I wrote in my brief, this statute is constitutional. And because a facial challenge to a criminal law has to be either an overbreadth challenge or a vagueness challenge. That's the law. And so we have to match up these doctrines with something that's wrong with this statute. If this court's going to say that the statute, the Maine's terrorizing statute before it was amended, criminalizes an amount of protected speech which is substantially overbroad in comparison to its plainly legitimate sweep, then this court can do so. But I don't think that that is what this court would find if it goes through that analysis. And I like to point
Your
to,
suggestion would be that somebody rarely makes statements that would be viewed as terrorizing that are actually protected. They usually do have the intent or other mens rea to
And in this
scare the
instance,
person.
it could be that in determining whether to plead guilty, he knew all about countermen, and he said, well, it needs a reckless mens rea, and they can prove that, so I guess I'll plead guilty.
exactly, Your Honor. That's how these cases should have been resolved across the state. It should
And
have
if
been.
you thought it was unconstitutional, there's a procedure available for that, to plead guilty, avoid a trial, get the benefits of pleading guilty, because sometimes, usually, oftentimes, the sentence may be better if you're pleading guilty than if you have a trial. And we can do what's called a conditional plea and still appeal whether the statute was indeed constitutional,
and
but that
trust me-
didn't happen here.
And trust me, Your Honor, I have spoken to many defense attorneys to try and encourage them to take that route. They have, I wish that that was this case, so it was more cleanly on this court's desk to make that decision. But on the constitutionality, I would like to highlight just a few cases on the overbreadth point. That in Broderick v. Oklahoma, the Supreme Court said that a law which requires state employees to get permission before doing certain kinds of political speech, they said, yes, that criminalizes some amount of protected speech, but nonetheless, that statute is constitutional because it is not substantially overbroad. In Cantwell v. Connecticut, this is going way back, a person was convicted for playing a phonograph of a Jehovah's Witness was playing a phonograph of his religious beliefs, and two other people were offended by that religious message, and he was charged and convicted with disturbing the peace. In that case, the court said, yeah, he can't be convicted for that, but there is nothing wrong with the statute. The statute can continue to be prosecuted, even though it is so overbroad that you can put somebody in jail for playing their religious beliefs on a public street. Even then, it has to be so overbroad that it is substantially overbroad for the plainly legitimate sweep, and this statute is not that one. Other cases of Brandenburg v. Ohio, where the statute actually was reversed, that one was prohibiting anyone advocating for industrial reform through sabotage or violence, and just advocating, no likeliness, which is required under the U.S. Constitution. So that would be pretty much any sort of inflamed speech at a political rally would fall under that. That was overbroad. And we can see how that makes sense, that the amount of protected speech which is criminalized versus the amount of unprotected speech which is criminalized, it's substantially disproportionate. It's completely
So you're saying
uneven.
it's not substantially overbroad?
Yes, Your Honor. I think that we have so many laws in this state which you could use to criminalize protected speech if we were to do that, right? Somebody burning a flag, right? They didn't get a permit to have
This is missing a mens rea. That's pretty big.
I don't want to dismiss that it is not an important point, but again, it can be in a jury instruction. And second, it has to be substantially overbroad. And if we can come up with a fact pattern that says, okay, a reasonable person would believe that this was a threat to them, but also the person saying it wasn't even reckless as to the threatening nature of their speech, it would be a very convoluted hypothetical. Thank you.
Thank you, counsel. Attorney Lawson, you wish to be heard in rebuttal?
Yes, thank you, Your Honor. To respond to a few points, overbreadth is not the only way to invalidate an unconstitutional statute. In fact, that's kind of a secondary analysis. The traditional approach, which is still alive and was applied, if you look at the case of U.S. v. Stevens, which I cited in my brief, the court just looked at the face of a statute and says, can it be applied? This one cannot. As Justice Meade pointed out, how do you implement this in jury instructions? There is this in fact element, this language in the law. A court will violate the separation of powers if it just strikes that out and grafts on a countermand compliant element. It's not just that the element isn't there. Is that the word in fact, the legislature expressly took it out of the law. And for that reason, it's unconstitutional on its face. It's not valid. It can't be used in any trial.
So just to underscore that, the speech we're talking about here in this case is what we call in the trade a true threat. It's not a joke. You say, I'm going to do this, and it's intended to be a threat. Wouldn't that be on the lowest scale of, I mean, the First Amendment is primary in our Constitution, but protecting true threats, shouldn't that be at the bottom of the scale of the kind of speech that we want to protect?
Your Honor, there is no scale. Speech is...
Core political speech is protected a lot higher than other kinds of, say, commercial speech under the First Amendment. There is a scale, isn't there, under the First Amendment?
In that context, there might be.
Well, political speech, they say political speech is the highest level of protected speech, that politicians can say pretty much anything running for office, and that way back 200 years ago, the court said, we're going to leave it up to the electorate to decide whether that speech is. But you're saying, your answer to my question is we shouldn't put it on a continuum and look at true threats down at the bottom of the protection scale?
In fact, in Counterman, the court said we should be especially defensive about protecting speech that people find offensive. And the reason is because I think the language was the thumb will weigh heavily on suppressing such
But you only have to do recklessness under Counterman, which is a pretty low mens rea. Isn't that reflecting that it's not our most protected speech?
That you should have, even if it wasn't intentional, you should have at least been aware of the substantial risk.
It might be
going to scare somebody. They thought you really were going to kill them.
It might be a low mens rea, but it's an important one because it distinguishes between protected and unprotected speech.
Thank you, counsel. Thank you for your argument here this morning. For the benefit of the students as well, we don't tell you our decision right now. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
Lopez, and it's very nice to see you all this morning.
And I also understand that the superintendent, Sandra MacArthur, is here, so welcome to Ms. MacArthur. Is that in the back all the way? Okay. Waving. Come on in. Anyway, as I say, the next case, we actually have two related cases that we are hearing back to back. First will be Andrew Robbins et al. Versus the Maine Commission on Public Defense Services. This is Kennebec 25-137. Council are present, I'm assuming ready to proceed. If you would introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Your Honor. Sean McGinnis here on behalf of the appellants, the Executive Director and Commissioners of the Maine Commission on Public Defense Services.
Thank you. And for the plaintiffs.
For the plaintiff appellees, my name is Zachary Hayden. I represent Andrew Robbins et al., the class in this case.
Thank you. And Attorney McGinnis, if you are ready to proceed, we'd be happy to hear your argument here this morning.
Thank you. Madam Chief Justice and Associate Justices, may it please the Court. This appeal arises out of the Superior Court's jurisdictional overreach and an error of law. The jurisdictional overreach is what requires immediate review, and the error of law is what requires this court to vacate.
If you could keep your voice up, you would think that we could hear you really well. Some of these are magnifying our voices more than others, as I understand it.
I will project, thank you. The error of law requires this court to vacate the Superior Court's judgment. After severing plaintiff's claim from 2022, After severing plaintiff's 2024 claim alleging non-representation from plaintiff's 2022 claim, which alleged insufficient training and supervision of lawyers, the Superior Court's summary judgment on the Phase 1, this is the non-representation claims, led to a series of orders directing MCPDS to prioritize successive subgroups of criminal defendants. The Superior Court's conclusion of law on the scope of the Sixth Amendment ignores over 40 years of precedent in this court as well as in the United States Supreme Court. Since Cronick and Strickland were decided on the same day in 1984, the Superior Court's judgment mandates...
Counsel, I see that the green light is on. I mean, there's no question that defendants in criminal proceedings who are subject to incarceration are entitled to appointed counsel if they cannot afford an attorney, correct?
There is no question that that is true.
And there's no question, is there, that that right attaches at the initial appearance?
Attachment of the right does occur at the commencement of prosecution, and the initial appearance is certainly...
Initial appearance or arraignment, whatever the commencement of the prosecution.
Yes.
And we can put aside the question of presumably that may be satisfied by what we call Lawyer of the Day program, but putting that aside, that doesn't end after that. The right to have counsel doesn't end, correct? It continues.
The right to have counsel attaches at the initial appearance, and it continues throughout the trial.
Okay. So why are we talking about, you know, what's a critical stage or not? Is that more going to the remedy and what we do about it? I mean, we can all agree they're supposed to have lawyers, and some of these guys aren't getting lawyers.
The distinction that the court raises is an important one, and the distinction is one between the Strickland standard and the Cronick standard. Those were cases that were decided on the same day in 1984 by the U.S. Supreme Court. The Strickland standard is the default. The Strickland standard requires that a complainant, a criminal defendant, establish what would have been different or that they had some harm as a result.
But isn't Strickland an ineffective assistance of counsel case as opposed to a no attorney case?
There is no distinction in either Strickland or Cronick that limits it to a ineffective assistance versus a no counsel. In fact, most of the cases which address, including the case that was addressed in Cronick, were essentially that although there was a human being who was a lawyer who was there standing next to the defendants, that individual was a real estate lawyer with no experience in criminal law, with a 17-day lead time on a complex RICO case, and was effectively not counsel. So the distinction between chronic and Strickland is important, and that is the key to answering the court's question about why we're talking about critical stages.
Counsel, does the commission agree that the dispositional conference as it's currently structured is a critical stage?
Yes.
At what point between the time the right attaches at initial appearance and the date of the dispositional conference does the right ripen?
That is a question which was not answered or addressed in the evidence on summary judgment.
What is your position on
In terms of a number of days, Your Honor?
that? I'm not asking in number of days, it could be events, it could be any, but what's your position, what's the commission's position on when that attached right ripens? So that if an appointment is not made or an assignment is not made at that point going forward, you do fall then under the chronic standard, don't you?
The case law is clear, Your Honor, that an attorney in that scenario would require a reasonable time to be prepared for the dispositional conference.
And when is that?
That is to be determined, and again, to be clear, on the record here on summary judgment, there was no evidence whatsoever addressing the issue of reasonableness of an appointment prior to a critical stage. No expert evidence, for example.
Here's my threshold problem. None of the people in the class or subclass has actually been deprived of counsel at any critical stage. They've just had a delay in having the appointment of that counsel, correct?
That is correct.
So is this even a Sixth Amendment issue, or is it a speedy trial issue?
Speedy trial issue was not raised and did not come into the case below, Your Honor. In terms of the delay issue,
But that's what the remedy, I mean, we do have a requirement that trial occur within an appropriate time, and if it doesn't, that case is actually dismissed, right, for a violation of speedy trial. I understand it wasn't raised here, but is that the remedy for delay if it ripens into a speedy trial problem?
to the extent that there is a delay that ripens into a speedy trial problem, that does appear to be the remedy. Again, I'm hesitating solely because that was not at issue below in the Superior Court, Your Honor.
But if it's not a Sixth Amendment problem, it's a different problem. Maybe if it violates one of our rules as to days, it could be unlawful and be a habeas problem. But if it's not a Sixth Amendment problem, then we don't have the right class identified here, correct?
The identification of the class is an issue here. The class was identified as any indigent criminal defendant who does not have counsel immediately following initial appearance. So that is a very broad class. The Superior Court's conclusion of law that the Sixth Amendment right continues throughout, and any delay or any period without counsel sort of fits the class definition, but neither of those things are consistent with Sixth Amendment case law. In terms of chronic, what chronic said explicitly before reaching its holding was that it cited to a prior Supreme Court case saying, we are not going to hold that any delay in appointment of counsel is automatically a Sixth Amendment violation. And it goes to the Justice's point, which is that this critical stage analysis is crucial because without evidence of prejudice as required by Strickland, what chronic does is it establishes that there is a Sixth Amendment violation, full stop. There is no...
So there's sort of two parts to that then, as I understand what you're arguing, that the prejudice is they have, each individual essentially, in order to figure out an appropriate remedy, has to establish, A, that there is a delay in appointment of counsel, and B, that either the delay ripened to the point where they didn't have an attorney at what was a what everybody can agree is a critical stage, something like the dispositional conference, or that there is actual prejudice that affected or delayed, if you will, the right to a fair trial.
I would agree with that distinction between those two tests, Your Honor, and to be clear...
It's presumptively prejudiced if there's no attorney at an actual adversarial proceeding.
That is correct, at what has been termed as a critical stage. And the key...
Can I ask you about the framework? As you know, the judge here below created a framework that would apply across the board to the entire class, and provided if detained for 14 days would trigger release. If detained for 90 days, that would trigger dismissal. And it sort of levered in some issues that some individual characteristics might be looked at, but is that too broad a sweep to simply say, as an interim remedy for habeas corpus, to say I'm creating this framework, and then we'll take it from there without individual attention to whether or not anyone was denied of counsel at a critical phase?
We are not the party responding to the habeas corpus claim. However, in terms of the distinction between, I think this goes back in our view to the question of whether there was in fact a Sixth Amendment violation.
Right.
Well, what's too broad about the remedy for count one? I mean, you're complaining about the remedy. You're really complaining about count one.
Yes.
Okay. What is wrong with what the judge did with respect to count one if we put aside the habeas?
Leaving aside the error of law. I'm sorry, I did not mean that.
Well, that one, she entered an injunction, right?
That's correct.
Okay. What's wrong with the injunction?
The injunction is effectively overbroad, Your Honor. What is happening is that the injunction on its face is fairly unobjectionable, which is that MCPDS has been ordered to provide representation to all indigent criminal defendants.
Isn't that what you're supposed to do?
That is in the statute, Your Honor, yes. So that is.
So what's wrong with that?
What's wrong with it is the application, Your Honor. What has occurred since the order has been successive orders from the Superior Court ordering MCPDS to prioritize selected subgroups of these indigent criminal defendants for immediate representation, or else there will be a habeas hearing or series of them, and these folks will be released. That is a massive overstep in terms of the court's jurisdiction, and although there have been statements in the opinions that the court is not looking to manage MCPDS, that is precisely what has been done here by identifying subgroups of indigent criminal defendants to whom MCPDS is ordered to provide representation within a specified period of time. Some of those were based upon where people were being incarcerated, others were based upon where the court envisioned having habeas hearings. With respect to the argument on appeal, Your Honor, the other issue beyond the application of a proper standard, again under chronic, is the absence of plaintiffs having any proof of a named plaintiff without counsel at a critical stage. Again, we do disagree.
I'm sorry, I didn't hear exactly what you just said. The absence of what?
Of any evidence on the summary judgment record from plaintiffs establishing that a named plaintiff was without counsel at a critical stage. The evidence.
Do we have any evidence? I mean, the differences between the continuous and the kind of distinct criminal stages. If we accept that it's continuous, is there anybody within a class representative that never had an attorney in between critical stages after the initial appearance?
There is no dispute that among the class members and among the named plaintiffs, there have been delays in appointment, so that there are named plaintiffs, and I believe that plaintiffs have identified two.
They'll have an attorney, a lawyer of the day at the initial appearance, and then one is in an order saying, I'm going to appoint an attorney, but no attorney is actually
Wasn't it
appointed.
also undisputed, though, that there were some members of the subclass who reached a critical stage and did not have counsel?
Well, the key decisional point here, Your Honor, is whether there were named plaintiffs, and this is important for two reasons, one of which is that this is a class action. There needs to be a certified...
Put that aside for a moment. I understand they're not named plaintiffs, but the record does establish that there were members of the class or subclass who reached a critical stage and were not represented by counsel.
I think that the court is referring to one of the statements of material fact that have been submitted by plaintiffs, and our response...
Which is labeled an undisputed.
I believe our response was that it was qualified, Your Honor, and the issue there was that the evidence submitted did not support the assertion.
So there's a disputed material fact.
There was a disputed material fact, Your Honor. The evidence submitted in that case were docket summaries that addressed dates, and that did not support the assertion that was made. I see the red light is on.
Thank you, counsel. Attorney Hayden.
Good morning. May it please the court. This is a case about the guarantee that a person accused of crime who cannot afford an attorney will have one provided for them by the state. It's a guarantee found in the Sixth Amendment to the United States Constitution, Article 1, Section 6 of the Maine Constitution, and it is a promise that the appellants in this case have broken. As a result, hundreds of people have waited weeks or months, long after the point where the right to counsel attaches, for their lawyer to show up. They've had nobody to provide guidance and advice, nobody to investigate, nobody to engage in the adversarial process, nobody to get the case moving. And the trial court in this case found that that constituted a systemic violation of the Sixth Amendment rights of the class. That decision should be affirmed, and I'm happy to answer your questions.
Do you agree, counsel, that as far as the United States Supreme Court jurisprudence is concerned, that the trial judge's decision went beyond that?
No, Your Honor, I don't agree that the trial court went beyond what the U.S. Supreme Court has said. What the U.S. Supreme Court has said, and I think this responds to an issue that Justice Connors raised in the earlier colloquy, is that there are critical stages that begin, they start right after arraignment, right?
When do they, what's your position as to when that starts? Is it the moment after arraignment? Is it
soon after arraignment?
Well, what's the difference between 7 days and 10 days and 14 days and 21 days in the abstract?
I think at some point, and this goes to the remedy that the court considered carefully, held a trial about, and then ultimately applied, after 2 weeks of somebody sitting in jail, that deserves a remedy. But that's not the same thing as saying that's when the constitutional injury begins. The constitutional injury, according to the U.S. Supreme Court, begins when somebody has not had counsel after a critical stage.
That's the problem. I mean, really what I think, what may be overstated here is there's a clear violation if there's no attorney at a critical stage, and if we define that, I think, certainly we can all agree, as we said, that something like the dispositional conference is obviously a critical stage. Anytime there is an adversarial court proceeding, that is clearly a critical stage, and I don't think the state is disagreeing with that.
That's true, but that's not the only thing that's
well, that becomes the question, but isn't it a matter of, isn't the significance what you have to establish in order to obtain a remedy? In other words, that if there is, in fact, a critical stage where there is no attorney, we can all agree that that may derogate the right to a fair trial. But if there's no attorney, 20 days after arraignment, that may or may not derogate the right to a fair trial. I mean, isn't that true? I mean, it depends. We have plenty of cases where there are no pretrial motions that anybody's filing. There's not an issue of competency. There's no motions. I mean, But in every case, if there's going to be competent representation, the defense attorney at least needs to consider whether they're going to file any pretrial motions. They do, but the question is when the non-lawyer can't do that. But there's no question that the right attaches. The question is when is there, isn't the issue when is there actual prejudice in order to obtain relief from the violation? So what the United States, and I'll just disagree with my friend from the other side about the distinction between chronic and Strickland. I think that's critically important here. What the Supreme Court has said in chronic was when there's actually denial of counsel, then prejudice is presumed. And the distinction, I think Lucky versus Harris, the 11th Circuit decision, talks about this distinction in a really clear way. Why we think about Strickland as having this additional prejudice requirement isn't about what stage the person didn't have counsel. It's about the fact that there's been a verdict entered in the case, right? Strickland is the issue of post-conviction review, and where you have a concern, which this court has expressed, about the finality of those decisions, we're going to require this additional showing of prejudice.
So what you're saying
when we're talking about
you're saying that it is a constitutional right under the Sixth Amendment that someone have a court-appointed lawyer that represents the person from the time of the appearance, every single moment between the appearance through the trial.
It's a constitutional right to have counsel at critical stages and in advance of critical stages to prepare. And the trial court, relying on US Supreme Court precedent, identified 3 important critical stages where people, the class members in this case, have been denied counsel.
What are those 3, counsel? What are those 3 critical stages?
I'm glad you asked. One of them is for plea negotiations, which under Maine law can begin right at arraignment. Right. And the US Supreme Court in Lafleur, in Fry, and Padilla says that people have the right to counsel, to assist them in plea negotiations, to counsel them, and also to engage.
No question about that. What are the other 2?
The other is bail hearings, right? In Coleman versus Alabama, the US Supreme Court says.
Let's stop right there.
Yes.
Has the US Supreme Court said that there's a right, Sixth Amendment right to counsel in a standalone bail hearing?
The Supreme Court in Coleman said
Coleman was not a standalone bail hearing. Coleman was a pretrial evidentiary preliminary hearing at which the court also considered bail.
Right.
I want to know, is there authority for a standalone bail hearing as a critical stage?
I see what the court said in Coleman, which is that the reason that proceeding is a critical stage is because there's a discussion about bail, because somebody's liberty interest is being decided, and because they can't engage meaningfully in that adversarial process without the assistance of counsel.
But what you're really saying is, as I understand it, is not so much that people had to engage in these processes without an attorney, but that because what really happens is that because there's no attorney, these processes get delayed.
That is definitely the case, Your Honor. That's definitely a problem under the Constitution.
But isn't that a different issue? I mean, isn't delay a different issue?
No, and this goes to the question Justice Connors was asking earlier about whether this is a speedy trial issue. You can't bring a speedy trial claim unless you have a lawyer. Nobody is going to be able to know how to articulate that their right to a speedy trial.
You'd be surprised how many letters I got saying, as a trial judge, I'm not getting my speedy trial.
An effective speedy trial claim.
But in terms of a remedy, whether or not it's moved for, that's a potential consideration, isn't it?
These endless delays of weeks or months. At the time we had the evidentiary trial, it had been an average of 2 months.
This is what I'm trying to get my head on. Why is this a Sixth Amendment issue? Delay is bad, but everyone in your class, for those 3 periods of time, they have lawyers.
Well, no, what they have sometimes, they do not have lawyers for those 3 periods of time. They do not have lawyers for the pretrial investigation, which was the 3rd phase that I didn't
Well, they do eventually.
But not after that, long past the time when they've suffered an injury,
I'm not trying to defend
injury,
that
right?
it's a good thing.
And what's troubling about the arguments of my friend the other side is that there's volumes of evidence about those injuries, and it comes from MCPDS itself. It comes from their standards of practice, which say that a lawyer needs to meet with their client within 2 days of arraignment.
I think that the challenge, counsel, though, is if the trial court is correct under Supreme Court precedent that it's effectively a continuous right from the first appearance on, it swallows the critical stage analysis. What's the purpose of having that analysis if it's just a clear, bright line rule from day 1 on? There's a violation.
I don't think they're saying that it's the Supreme Court has said that it's a bright line rule from the moment
Right,
on.
they haven't, but that's how the trial court said that.
But they have said that there are critical stages which under Maine rules and Maine practice do commence very soon after arraignment.
Well, what the trial court essentially said here, and what you're arguing, is that the critical stage is everything. I mean, it's basically from the moment that it attaches on up, it just continues.
No. What I've said and what I meant to say is that the critical stages, the 3 that the court identified, pretrial investigation, bail arguments, and plea negotiations, do commence very soon after arraignment under Maine practice, under our Maine rules that allow, that require counsel to be appointed right away, under a Maine statute that says that plea offers can be made by the prosecutor right away. And the MCPDS at the trial did not contest this. In fact, they said exactly this. Your former colleague, Commissioner Soucy, said that a person needs a lawyer to start work right away because
nobody's disagreeing that that would be the better, and that there is the right under rules and under the Sixth Amendment, the right attaches.
Right, and what the Ninth Circuit said in Betchart, which I think was very helpful, is that the Sixth Amendment is not a haphazard jack-in-the-box right that pops up at arraignment, disappears, then pops up again at some later step. Once the right attaches, and you hear this in a number of the Supreme Court's decisions, then it attaches, and people have the right to have that right carry them through.
But even in the Rothgary case, the court was very careful to say that in that instance where the defendant appeared before the Alabama magistrate, had a bail hearing before the magistrate, the right attached, but there was it didn't ripen at that point. Even in Rothgary, they said this was decided the same day or close in time to Lafler, right?
Yeah.
So even there in Rothgary, the right didn't ripen at that initial appearance.
Right, so Rothgary involved this strange proceeding, this magistration proceeding.
Right.
But if you go back, it's fascinating, on your drive back to your home courts and listen to the oral argument in that. At one point, Justice Scalia says, are you saying to the Texas attorney that somebody could have their right not attach and they could be sent to jail for 3 weeks, and that there would not be a Sixth Amendment problem with that? And the counsel for Texas said yes, and Justice Scalia said, really? That can't be right. Holding somebody for weeks or months when they're entitled to counsel cannot satisfy the Sixth Amendment.
Why? Being held in jail is not necessarily relevant to the Sixth Amendment right. In other words, somebody has the right to have appointed counsel if the potential sentence involves jail.
Yes.
That is true whether or not they are being held pre-trial.
That's true.
And I think what I struggle with is, why is release from jail or dismissal of charges, but we're veering over really into the other arguments, how does that relate to the Sixth Amendment right? I think they are concerned about the scope of the injunction, though, in this case for count 1 is where we are.
That's right, but when you look at the injunction or the habeas remedy, it all comes down to the same thing. It's the state that initiates the criminal case. It's the state that decides when they're going to proceed with the criminal case.
I'm getting hung up on the class. So we have 3 critical stages that I understand you're saying it's continuous, and the reason why it's continuous is because there needs to be things that lawyers are doing in between the critical stages to prepare. But assuming that is the case, the amount of time that a particular case would need for preparation in each of these critical stages would differ. So how can there be commonality as to liability if it varies?
Here's what doesn't differ. For every one of those cases, the defense attorney needs to meet with their client. They need to interview their client. They need to obtain discovery from the prosecution. They need to review that discovery.
And they will do that once appointed. It's just a matter of delay, not complete deprivation.
And they need to conduct an independent investigation of the facts, right? They can't rely on the police's version of the facts. So their ability to form an attorney-client relationship with that person, their ability to conduct that interview has deteriorated as that person has sat in jail or sat waiting for them to show up.
You're saying kind of fact-based things that could vary.
This is true for everybody, right? This is true in every case. There needs to be an initial interview.
Well, it's true there might be a need for an initial interview, but it's not true that what follows is necessarily going to happen, right?
These are the things that do follow in every one of these cases, right? There needs to be an initial interview. There needs to be seeking and obtaining
Yes, but
discovery,
in one
reviewing
case, it
discovery.
may matter a lot that doesn't happen immediately, and that they get witnesses whose memories may disappear, who are evidence that's fresh, et cetera. But in the next case, it won't matter at all. There's plenty of cases where there was none of that matters.
What the Supreme Court says in Chronic, and has carried through in the cases in the decades since, is that when people are deprived of counsel, it's too burdensome to require them to have to prove how that...
So does your argument then really turn on, do you agree that if we disagree that everything from arraignment on is considered a critical stage, then the injunction in this case does not stand.
Well,
And
I think the
declaration.
injunction at in this case could be premised solely on the issue of plea negotiations, which we know can begin right at arraignment or soon after, and which
Sometimes.
person needs to prepare for.
Thank you, counsel.
Thank you.
And Attorney McGinnis, I think you reserved 3 minutes for rebuttal. It's hard not to slide over into the remedy part of this and the habeas issues.
It is a procedurally complex situation, Your Honor.
But my difficulty is trying to understand.
The class.
Yeah, how is everyone in the class, there is a liability problem for every single person in the class. If there are unless you have to have the lawyer always for every moment from soup to nuts.
That's essentially our position in terms of there is the class and the Superior Court's judgment do fit together in terms of the only way that the Superior Court could find liability in this case is to determine that immediately after an initial appearance and throughout there is a Sixth Amendment violation if one has any delay in the appointment of counsel. Our point with respect to a named plaintiff is precisely that, Your Honor.
But what about opposing counsel's point, which is that how do you know in any given case? I mean, you need to conduct the investigation. You need to have the interview. You need to look at the materials, don't you?
What's primarily missing and what distinguishes this claim from the claims, for example, in Betchart, which has been cited significantly in plaintiff's briefing, is that at the beginning of each of those cases, there was a litany, including 10 to 12 individual plaintiffs, and there was a description of what happened to those plaintiffs, including, in many cases, including in Betchart, not having a lawyer for 10, 12 bail hearings, standing there and having the judge tell them, if you waive your right to counsel, I will give you bail. Not intending to prejudice that person's rights, but essentially saying, I can't go through this, this process.
Let's say we agreed with you on that. What are you asking us to do? Remand for a trial?
What we're asking, what defendants are asking, Your Honor, appellants, is a remand and a explanation of the proper Sixth Amendment standard under chronic to the Superior Court.
But assuming there are facts still not developed, or facts that you disagree with, does there need to be a trial, another trial on the liability phase? Because as I understand it, the trial that was held was not on liability, it was on remedy only.
That's correct. We're at a summary judgment stage here, Your Honor, so the issue is one of summary judgment. And there were cross motions, defendants, appellants' motion for summary judgment was essentially that plaintiffs had no evidence supporting a named plaintiff having no harm.
Are you asking for a remand for a trial on that issue?
No, Your Honor, we're asking
For actual prejudice as to each plaintiff, or?
a named plaintiff,
Or
Your
named
Honor.
plaintiffs.
One named plaintiff. Among the cases that we've cited is a Tucker case out of Idaho that's relevant to a Maine appeal solely because that appears to be the only case in which the trial standard for this kind of claim was addressed.
So in this summary judgment record, we won't find anywhere that Robbins or any other named plaintiff ever established that they were denied counsel at a critical stage?
If I understood the court's question, I would agree with that in terms of the
As
summary
you
judgment.
define critical stage.
I'm sorry?
As you are defining or asking us to define critical
That
stage.
is the primary distinction, yes, Your Honor.
Justice Lopez, you were trying desperately to get a word in.
It's fine, it's been taken care of, thank you.
Okay.
Thank you.
Thank you, counsel. One of the advantages I have as chief is I can ignore the red light if I choose to. Thank you, counsel. I think we're really not done here. There's sort of a part 2 to this argument, but at this point, we are complete with this one, and we will take the matter under advisement. Intermission.
All right.
And you may be seated. And we are here essentially for part 2 of Kennebec 25-137 Robbins versus, in this case, we'll call it the state of Maine. And I know there's been a change of counsel, so I am going to ask counsel to identify yourselves by saying your names for the record, together with the party you represent.
Good morning, Your Honors. Paul Suter, Assistant Attorney General on behalf of the party in interest appellant, State of Maine.
Good morning, Your Honors. Carol Garvin on behalf of the plaintiff, class Robbins et al.
Thank you. And Attorney Suter, if you're ready to begin, we'd be happy to hear your argument this morning.
Thank you, Madam Chief Justice, and may it please the court. No one disputes that the indigent criminal defendants at the heart of this case have genuine constitutional and statutory interests at stake. The state of Maine is not here to obstruct the right to counsel, but to simply correct the legal and practical errors made by the Superior Court in ensuring it. Immediate intervention is necessary because the Superior Court's order allows for release and dismissal of charges across Maine, including those accused of violent felonies, even when it could undermine justice, endanger public safety, or contradict the law. Assuming its Sixth Amendment analysis was correct, the Superior Court's Count 3 relief suffers from at least 3 serious flaws. Abandoning an individualized assessment required by Maine statute and the federal Constitution, imposing an ultra vires dismissal of charges, and it creates a roving release protocol that breeds confusion and erodes public trust in our justice system. No precedent exists for the protocol. Instead, this court, the Superior Court should have followed models established in Oregon and Massachusetts, where local judges familiar with the area's legal community are much more likely to be successful in securing counsel and making habeas release unnecessary.
I see that the green light is on. Can I start with a really basic question? You have designated the state of Maine as a party in interest in this case. I note that there is no such creature in our rules. Are you founding that designation by under 14 section 5522 of the habeas statute, which specifically says that the Attorney General shall have the right, must be notified, may appear and object? Is that what gives you essentially that status?
Your Honor, I think that's one area that status could come from. I also think that I believe the Superior Court designated the state of Maine as a party in interest in light of the Peterson.
Designated the state as a party in interest, but I'm noting there is no such creature under our.
That's entirely fair, Your Honor. I believe, yes, certainly under Title 14, the state or any interested party has the right to participate in a habeas review. And so certainly, I think the state's participation at this stage is appropriate, although I don't think that the state's participation thus far replaces the other aspects of that statute that allow others to participate before someone is released.
So let me focus on the habeas statute that says every person unlawfully deprived of his personal liberty has a right to the writ. So unlawfully deprived would be bigger than a Sixth Amendment violation. It could be you're violating a statute, maybe a rule. Do you think that any of the people that are a part of the class here have been, their liberty has been withheld contrary to a statute or a rule?
Your Honor, Justice Connors, I'm not entirely sure because I'm not sure we have a full understanding of exactly who makes up the class. But it's, I suppose it's possible that some members of the class have suffered from some violation like this, although I don't know that there's a representative violation across the class.
Are you saying that you can never have class certification for in a habeas action?
I don't know that that's necessarily the case, Justice Connors. I don't know that the class certification, or certainly the subclass certification, was conducted appropriately in this case. That's not something that the state of Maine has raised as an objection to the relief that has been issued, but certainly I think the difficulties of a representative class are the issues that come up with that are exacerbated, or they come to light at the end of this stage when it comes to whether or not someone deserves to be
But doesn't
released.
the class certification raise the complexity level significantly because we have to get through that door to begin with? To look at, and it's within that class, there may be people in vastly different circumstances. Some might qualify, some might not. Wouldn't this have been easier just to have addressed it on a single case or a group of cases, less than a class certification?
I think that potentially could have been an alternative route, Justice Mead. Admittedly, the class certification sort of process and decision came before the state participated, when the identity of the parties was a little bit different, before the complaint was amended.
Isn't the problem with that approach potentially that was similar to what happened in the Peterson case? In other words, you have named defendants or named petitioners, and then all of a sudden they get appointed counsel, and they're no longer, the case is moot as to that.
I certainly appreciate, Justice Douglas, a possibility of repetition that's escaping review. I don't think that is something that's at issue here. Certainly a class could be potentially could be constructed or thought of in which someone would have been a representative plaintiff but for the fact that they received counsel, similar to, I think, the way a lot of abortion litigation
Let me follow up on Justice Connor's point. If there's a violation of statute, that's potentially an unlawful act, correct? We have a statute, don't we, in Title 15 that requires before arraignment, competent defense counsel must be assigned by the court. And now, are you confident in saying that that is, if the accused is charged with a felony, basically, are you confident in saying that no member of this class who's been charged with a felony has been deprived of competent counsel at arraignment?
I'm not sure we're aware of what the status of any member of the class is, Justice Douglas. I don't know that there's a lot of available information about specific members of the class at this point. The state has not, at this stage, participated in discovery, so we haven't explored potentially these types of elements. But I do think at the end of the day, certainly the plaintiff's case is brought under the Sixth Amendment and its main Constitution corollary. So to the extent that there are other potential violations of law, I don't think those are before the court, at least at this time.
So you're saying we shouldn't go beyond whether this is a Sixth Amendment violation and whether it violates a statute or a rule, and you could possibly have a habeas under that unlawfulness?
I think, Justice Connors, this is the vehicle that the plaintiffs have chosen to bring. They've brought an action under Maine's habeas statutes under Title 14, and I think we're obligated to take the case that has been brought before us in terms of both following the Sixth Amendment claims, but also the textual commands of Maine's habeas statutes.
Can I see if I can summarize where I think you're coming from and make sure I understand it? First, that you agree with the Public Defense Commission, the Public Defender Commission, that the court's analysis of the Sixth Amendment violation was wrong in the sense of it was overbroad, that not everything is necessarily a critical stage from arraignment on, and that if we then move into a habeas proceeding, you must first analyze each case separately with regard to whether that person individually is A, being deprived of counsel under the proper analysis, and then B, what the proper remedy would be even in a habeas. In other words, that Section 5523 actually only authorizes discharge from custody, not dismissal of charges, and that in making that analysis, particularly for felonies, you must consider what is the appropriate public safety and other considerations under our bail statute. Did I summarize that correctly?
That was an excellent summary, Chief Justice Stanfill. I don't know that I could have said it better, but yes, that is certainly the position that.
Can I follow up on that question?
Absolutely, Justice.
This class includes people charged with felonies as well as non-felonies. Your position on the statute and the provision that the following person shall not of right have such writ, including felony, does that block them out, or do they come in by grace of the court?
So the state's position, Your Honor, based on the text of the statute, the history of the statute, as well as this court's precedential decisions, is that they don't have, citizens charged with a felony do not have an absolute right to relief the same way someone charged with a misdemeanor would, but that doesn't mean a court could not offer them relief. Although I think
the reason I asked the question is we were talking about whether each case has to be sort of micro looked at along the way. So felony cases would have to have that additional layer of scrutiny to get in under the door to habeas,
And
correct?
it sounds like to follow up on that for a misdemeanor, if it's an illegal restraint, discharge is automatic. For a felony, if it's an illegal restraint, you still have to decide whether discharge is appropriate.
I think that generally is correct, Chief Justice Stanfill. I don't know that the state would have an argument if someone was only charged with a misdemeanor.
The court's framework that laid out the 7 days, release, 60 days, dismiss, did that paint too broadly? We're talking misdemeanors, we're talking felonies, we're talking about individual circumstances. Is that framework workable?
I really don't know that it is, Justice Mead, for two reasons. One relates to the statutory requirements of who's allowed to participate in such a hearing under Title 14, but then the other aspect of why it's just not workable has to do with the other specifics of any member of the class. The order does not distinguish between someone who had a lawyer up through their dispositional conference and then had the lawyer withdraw for some reason.
Can you help me understand that a little bit more? So if we proceed on the notion, I know you're not conceding this, but assuming there was a Sixth Amendment violation, then we get to the habeas hearing. The nature of the Sixth Amendment violation here was under chronic, so we presume prejudice, but your argument then is that at this hearing, we can then a court could examine the degree of prejudice in determining whether release is appropriate. Is that the argument?
Yes, Justice Lopez, I believe that's one of the things that the court could examine. I think the other things that it would need to look at is if there's an alternative lawful basis for restraining someone, which I don't believe the order distinguishes. So there might be someone charged with multiple crimes in 2 different jurisdictions that has an attorney in one jurisdiction and not in another. The order does not distinguish between that person and someone who has only been charged with one crime and doesn't have an attorney.
It does provide that there would be some sort of hearing, right? I understand you want it to be individualized by county, but it does provide for the justice in this case to have a hearing where presumably that sort of issue could be raised, no?
It certainly does provide for a hearing. I see the red light is on, if I may.
You can finish your sentence.
It does provide for a hearing, but I don't know that it provides for the type of hearing that is envisioned under Title 14 that Maine's habeas statute envisions.
Thank you, counsel.
Thank you, Your Honor.
And Attorney Garvin?
Good morning, may it please the court. Of all the rights that an accused person has, the right to be represented by counsel is by far the most pervasive, for it affects their ability to assert any other right. Those are the words of the Supreme Court in Chronic. Here, there is no real dispute that Maine is failing to provide counsel to hundreds and hundreds of indigent defendants. As of the time of our trial, there were over 900 pending cases where people had no counsel. The average time that people had been without counsel was 66 days. Where the dispute lies here is what the judiciary can and should do about that. The state is here urging the court to dismantle the trial court's remedial framework, which ordered conditional habeas remedies. In other words, ordered habeas remedies only as a last resort if the state continued to fail to provide counsel after reasonable timeframes. Instead, the state urges that the courts continue with the procedure of having weekly status hearings, where individual defendants are left where individual judges are left without guidance on how to figure out whether there's been a remedy, what kind of remedy they should order, and on what time frames. The state has been holding these weekly status conferences for nearly 2 years now. It has not resulted in any meaningful remedies, and our crisis continues to escalate. As the Massachusetts highest court said in LaValle when confronting a similar systemic crisis, the continuation of what is now an unconstitutional state of affairs cannot be tolerated. We urge this court not to stand by and let these lengthy deprivations of counsel become the new normal in Maine, and we urge the court to affirm the trial court's meaningful remedies. I'm happy to hear the court's questions.
Why is a person's restraint illegal because of lack of counsel? And let me be clear. If you have someone that is charged with, say, a serious Class A felony, a violent felony, bail has been set high, a determination has been made that it is appropriate to require very high bail, and the court orders that counsel be assigned, no counsel is provided, at least not in the timely fashion that we say should happen essentially immediately. That is a violation. But why, under the habeas statute, that is intended to remedy an illegal restraint? Why is that restraint of this person who there is probable cause to believe has committed a serious violent felony, who is being held on significant bail as a result of all of the circumstances? Why is the restraint illegal because of lack of counsel?
So the restraint is unlawful because they have been deprived of their basic structural right to counsel, and they are being held by the state, who is then prosecuting them in violation of that basic right.
Well, assume
and
that they're not required to go to at least an adversarial court proceeding without counsel. In other words, even if it gets scheduled, it gets delayed because, we can't do that without an attorney. We can't do a bail hearing without an attorney. We can't, all the things. Assume that that is the case, as opposed to making somebody go through trial or something without an attorney.
So all of the individuals in this class have been deprived of counsel for some period. The average, again, at the time of trial was over 2 months, and many of them are getting any kind of proceedings delayed again and again because they still don't have counsel. So they're not able to prepare for and advance to critical stages. They also don't have counsel during the critical stages that my brother talked about.
But I guess I'm still left with why that makes their restraint illegal, as opposed to, obviously if there's enough delay, it impacts, speedy trial rights. It may even impact due process rights more generally. But why is it a restraint? Does the restraint become illegal?
So I think I'd commend the Ninth Circuit and District Court decisions in Betchart, because it really addresses exactly the same issue under the habeas writ, and there concludes if the state is depriving someone of their liberty and denying their right to counsel because they are not provided counsel during all of these critical stages, during plea negotiations, during bail hearings, during the pretrial critical investigation phase, then that is an unlawful restraint on their liberty. So that is what habeas.
Is Betchart your only authority for that proposition? Because LaValle and the Massachusetts cases come down in a different place for a different reason. Is is Betchart the only case which holds that for that proposition?
So Betchart is both the District Court and Ninth Circuit decisions, both are habeas cases. The LaValle case uses a different equitable remedy, but all of these, it uses the 4 MRS 7 equivalent in Massachusetts, which goes to this court's basic equitable remedies.
It was also based on the Massachusetts Declaration of Rights, not on the Sixth Amendment.
That's accurate,
and
yes.
Even though it's been asserted here, the argument that the Maine Constitution also provides a greater right, or has not been developed. So we're really looking at this as a Sixth Amendment case, correct?
So we've raised very plainly both Sixth Amendment and Maine constitutional claims.
But you haven't separately developed a Maine constitutional argument.
We did below, because of the way the trial court ruled, both of those are the basis for the habeas count, but the trial court ruled that there was continuous
What is in front of us is only a Sixth Amendment challenge. It's not based on the Maine Constitution.
The habeas count is based on violations of both.
Of the habeas, of the writ.
The habeas writ, yes. The habeas writ, because the way that this case developed, there's a Sixth Amendment finding of violation under the summary judgment order. The state then agreed.
But you're not arguing that this is also a violation of Article 1, Section 6 of...
Or that it is, but that you're not trying to distinguish it as setting a different standard.
We are arguing that there's both a Article 1, Section 6 and Sixth Amendment violation. Those were both the bases, and the trial court order was very clear. Those were both the bases for the finding of a habeas writ needing to issue. We, along with the state, stipulated that the Maine Constitution is at least as broad as the Sixth Amendment right, and because of the way the trial court ruled, we didn't argue that it was even broader under the Maine Constitution. If this court construes the Sixth Amendment differently than the trial court, then certainly we would have argument that the Maine Constitution is what the trial court held for the Sixth Amendment as well. In other words, the Maine Constitution, just like we argue for the Sixth Amendment, requires continuous representation and representation at all critical stages.
Can I just change gears just for a quick second here? The court below issued what we're calling a framework, which is, I think it's more in the nature of a standing order, but the framework established what would happen in certain circumstances, established benchmarks, so to speak, but still left the wiggle room for some individual attention to individual cases. Is the framework a habeas relief vehicle?
Is the framework a kind of habeas relief?
It seems like it's more of a procedural tool as opposed to relief, because it doesn't provide the individual's relief. It just says that at a certain point this will be looked at.
Right. I mean, I think we are here on a somewhat preliminary stage because none of those habeas hearings have happened yet, obviously. Right. But yeah, the Supreme Court is doing something very similar to the LaValle Protocol that then was affirmed in recent years, the Betshart Protocol. So it's really a protocol to say when the number of days.
It's protocol. And my question, what I'm leading up to is, as the Supreme Judicial Court, we have a supervisory role. We can do things like setting out benchmarks and setting protocols, but can a single trial court justice create a standing order that governs all the other judges and justices and us in the process, or is that overstepping the trial court's role and prerogative?
Thank you. I think there was an appropriate exercise of the court's discretion here. It is the court that's been assigned to a statewide class action. We have statewide deprivations of counsel. So it's appropriate that the court is looking at what is a protocol for that entire class. Here now the court is in the position of being able to review that and affirm. So an alternative way that this could be approached is that if this court wanted to affirm that framework, it could then be sent back to the trial courts to implement it at a local level. So that would be an alternative, is to affirm the binding nature of the framework, the 14-day and 60-day time periods, and then individual judges could be the ones to actually implement those remedies in their courtroom. So that, as we explained in our briefing, is an alternative here.
The LaValle Protocol calls for a single justice of the Supreme Judicial Court to oversee that process, doesn't it?
That's right. LaValle was under yes, and then it sent it back down to I think the sort of equivalent of the trial chief to actually implement the specifics of that.
If those individual habeas hearings occur, is it the plaintiff's position that the only showing that needs to be made is that there is a lack of counsel has not been assigned, and you're beyond whatever the crucial date is, period, no further consideration given to any other factor? Is that the plaintiff's position?
So I think there's a few different considerations under the way that the trial court framed it, which I think is correct. So first, there's the question of whether the person is within the class. So have they been without counsel? Next, there's the question of have they been without counsel for the requisite number of days. Then, because the court was really clear, this habeas remedy is a last resort. The primary remedy is that they get counsel. So then there's a requirement that MCPDS would show they've made good faith efforts to find counsel, still haven't been able to find counsel. Then there's a couple of exclusions. For example, people who have murder charges are excluded. People who've repeatedly fired their counsel are excluded, so a number of those. And then if you get to all those points, then the court would consider the habeas remedy if they still didn't have counsel another 7 days after that habeas hearing. So it is a pretty,
talking about the remedy, though,
Public safety is not a consideration for any other petitioner?
So there's public safety was taken really seriously by the trial court in several different ways. So first, in constructing this remedy, the trial court did just what other courts like Betchard and LaValle have done, where the court crafted the remedy in order to preserve public safety. So there's not an outright habeas remedy. No one has issued a release from jail immediately.
The Superior Court ordered, though, that after a period of time, not only would the person be discharged, but if the lack of counsel continues, but the charges would be dismissed. Is that even an appropriate remedy under habeas and under 5523? I mean, the habeas allows discharge from an unlawful restraint.
Yeah, I think it's an absolutely appropriate remedy. So first, the source of this power.
How do you get to dismissal of charges then?
Because both for this court and the trial court, the source of this power is the common law habeas writ. The purpose of that writ, which has obviously existed for hundreds of years, is to free people from unlawful restraints. Those restraints can be a wide range of things.
So you get them out
so
on
that
bail,
includes,
maybe even personal recognizance, maybe even no bail, but that's different than dismissing the charges.
So the only remedy, and the trial court and Betchart recognize, the trial court in LaValle recognizes, the only remedy for people who have restraints, really serious restraints on their liberty because of pending charges or bail, is the dismissal of their charges without prejudice.
So you're
there is
saying
no
that
other way.
a person who isn't in jail is still being personally deprived of his liberty?
Yes, and the case law here is really clear. So Jones versus Cunningham from the Supreme Court, a whole line of cases, that habeas reaches a variety of restraints on liberty. That includes restraints imposed by
the
bail.
only remedy is discharge. Don't we have to pay attention to the statute?
So the statute says discharge from other unlawful restraints. It really carefully, I think in 5 or 6 sections, distinguishes between imprisonment and other unlawful restraints. And then it says discharge from unlawful
but it says
restraints.
Discharge, not dismissal. I mean, as I said, one could even argue not only lowering bail, but maybe even getting rid of a bond or bail or conditions, okay? The people get summons all the time without having bail at all. That would eliminate any restraint as you're defining it. It's still not dismissal of the charges.
So there would, 2 things, there still would be restraints on their liberty. For example, they'd be required to appear in court. The pending charges would be continuing to hang over their head. And so Supreme Court precedent has made clear even something like release on their own recognizance still is an unlawful restraint when there's pending charges and the government can compel their appearance.
I have a more practical question. I think the order said dismissal, until counsel is located, but effectively if the case is dismissed, nobody's going to be looking for counsel
because
for that
there's no
person.
longer a right to counsel.
Right. So what is the prosecuting authority, the state, supposed to do in that instance? Wait some period of time, recharge it, and hope that counsel is appointed timely?
Yeah, so I think that was added as another safeguard by the trial court to say, look, this is not the most extreme remedy. It is just dismissal without prejudice. I think that would have to be worked out in practical terms. We would hope, we all see the lists of counsel needed. We would hope that that would decrease. And so just like in LaValle, there'd be an understanding of we don't need this sort of crisis protocol anymore because the crisis has been addressed to a significant
Not to belabor
point.
the point, but isn't the problem is that that's not particularly practical?
So the dismissal without prejudice, I think, again, is a way to afford an additional accommodation to the state so that it is really clear we are trying to make sure that there's not dismissal unless absolutely necessary and those charges can be refiled. And this same process was followed in LaValle and it was workable there.
Thank you, counsel.
Thank you.
Attorney Souter, you wish to be heard in rebuttal?
Thank you, Your Honor. There are 2 points I'd like to make about why dismissal of charges is not an available remedy and why the law as well as practical considerations should feature into why any relief should come at the local court. When it comes to dismissal of charges, I think the text of the statute is key. The plaintiffs have brought their case pursuant to Title 14, and the only remedies that are available under those statutes are discharge or a lowering or possible elimination of bail.
I mean, they're suggesting that you can't be discharged unless you get rid of all of the potential restraints, including any conditions of release, obviously.
I certainly appreciate their argument, Your Honor, but certainly the precedent and any historical language regarding interpretation of the statute that we found simply doesn't comport with that. This court's cases have talked about freeing someone from the restraint of being hospitalized against their will, or possibly even a child who has been adopted into a home in violation of law. But those are physically restraining someone to a physical location. And I think the key is comparing the text of 15 MRSA 2130 and the remedies that are available under that statute and the ones that are available under Title 14. The legislature could have made more remedies available, but it chose not to. And actually, the difference in language highlights why local courts are really the better place to have these hearings anyway, as Title 15...
Counsel, are you conceding that habeas is an appropriate remedy here?
Justice Douglas, the state has certainly preserved any arguments related to the Sixth Amendment as the Public Defense Commission has asserted them, but we have not contested that if the Superior Court is correct, that they are being held in...
That's not my question. Is the state conceding that habeas is an appropriate remedy for a Sixth Amendment violation?
We understand you don't agree on what the scope of the violation is, but do you agree that it is an appropriate remedy for a Sixth Amendment violation, that becomes an illegal restraint?
I think the state would be willing to envision that it could be a remedy for some Sixth Amendment violations. I don't know that it would necessarily be an appropriate remedy for all Sixth Amendment violations.
What would be your example of a Sixth Amendment violation that would warrant a habeas remedy?
That would not warrant habeas?
That would.
That would. I think if there was an individual, Your Honor, who was found to have gone without counsel, up until trial, there's certainly no question that they've probably been held against their will. I will admit, or against the statutes of the state and the Constitution, but admittedly, those arguments are certainly, the Sixth Amendment aspect of this is preserved in the Public Defense Commission's argument. If I could just make one point, Your Honor.
I'm afraid the time is out.
That's totally fine. I appreciate it. Thank you very much.
Thank you. Thank you, counsel, for your argument here today. As I indicated earlier, our usual practice, and one we will follow today, is to take the matter under advisement and issue a written decision in due course. With that, we're going to be in recess on these matters. I do want to extend our thanks to all of you here in the Valley community for having us here. I hope it wasn't completely putting you to sleep. I did notice a few people may have been. And that maybe you got something out of it. I know that the lawyers are all willing to talk to you. We can't talk to you about the cases. I'm sure you wish we could, but we can't. I hope you could hear what was going on. I know the PA system was a little bit funky sometimes. But thank you for having us here today. You're welcome to come to a courthouse anytime and see proceedings. Go on down to Skowhegan. And see trial proceedings, which can sometimes be perhaps more interesting than the arguments in front of us. But thank you. With that, we will be in recess.